In today's lesson, we're focusing on how to talk about courts that operate above the national level, from human rights bodies like the Inter-American Court and European Court of Human Rights, to regional legal systems like the Court of Justice of the EU. You'll learn how to use professional, accurate legal English to describe what these courts do, explain how their decisions become binding, discuss issues of admissibility, jurisdiction, and enforcement, and use grammar structures that reflect the authority and limitations of these courts, including modal verbs in the subjunctive. Whether you work in public international law, cross-border litigation, or simply want to understand international legal mechanisms more clearly, this lesson will give you the tools to speak with confidence. Let's begin by activating your prior knowledge and expectations. When you hear supranational court, what images or cases come to mind? Maybe it's a landmark human rights ruling in the European Court of Human Rights, or a controversial decision by the Inter-American Court that a government is reluctant to enforce. Or perhaps the Court of Justice of the EU ruling that a national law violates EU regulations. These courts operate beyond national borders, but they still rely on national legal systems to enforce their decisions. Let's try completing these ideas. A supranational court is different from a domestic court because it can issue binding decisions that override national judgments under specific treaty obligations. In Latin America, the Inter-American Court can hear cases filed by the Commission or by states concerning human rights violations, even when domestic remedies have been exhausted. If a state loses a case in Strasbourg, it must comply with the European Court's judgment, even if it requires legislative reform or changes in national jurisprudence. These concepts will guide our vocabulary, grammar, and real-world examples throughout the lesson. In supranational law, jurisdiction is always the first question. A court cannot proceed unless it has the legal authority to hear a case based on territory, subject matter, time period, or party eligibility. For example, the court must first determine whether it has jurisdiction to hear the claim. Different courts have different jurisdictional limits. The European Court of Human Rights, for instance, can only hear cases against member states of the Council of Europe and only if domestic remedies have been exhausted. Similarly, the Inter-American Court may only exercise jurisdiction if the state has formally accepted it by ratifying the American Convention on Human Rights. Common phrases you'll hear include challenge jurisdiction, establish jurisdiction, lack of jurisdiction bars further proceedings. Understanding jurisdiction is key. Without it, a case cannot move forward. Even when a court has jurisdiction, a case must still meet admissibility criteria, rules that determine whether the matter is suitable for review. In supranational courts, admissibility often depends on whether all domestic remedies have been exhausted, whether the application is timely, whether the applicant has victim status, whether the claim is manifestly ill-founded. For example, the petition was dismissed on grounds of inadmissibility. This is common at the European and Inter-American Courts of Human Rights. A claim may be legally valid, but still be ruled inadmissible because the applicant failed to follow domestic procedure or submitted too late. You'll hear other phrases such as declare a matter inadmissible, admissibility criteria under the convention, or review the admissibility phase before examining the merits. Legal standing refers to who is permitted to bring a case before a court and whether they are sufficiently affected by the issue. For example, the claimant lacked legal standing to file the petition. In supranational courts, this is especially important. Individuals can file directly at the European Court of Human Rights. Before the Inter-American Court of Human Rights, individuals cannot file directly. The Inter-American Commission must first refer the case. In the ICC, legal standing may be limited to state parties or the prosecutor. Legal standing is about protecting judicial resources and ensuring that only those with a real stake can litigate. You'll hear key expressions such as demonstrate standing before the court, the application was rejected due to lack of standing, and standing requirements vary between institutions. When a supranational court issues a binding decision, it means that the ruling is not advisory or optional. It must be implemented by the state or party concerned. For example, the court issued a binding decision requiring legislative reform. This is central to the authority of courts like the European Court of Human Rights, whose judgments are binding under Article 46 of the European Convention. The Inter-American Court also issues binding rulings when the state has accepted its jurisdiction. But enforcement can be complicated. A binding decision may require changes to national legislation, reopening of a domestic case, compensation to victims, public acknowledgement of responsibility, and you'll hear some key collocations like issue a binding decision or fail to implement a binding ruling or challenge the enforcement of a binding outcome. A preliminary ruling is a unique procedure, especially within the Court of Justice of the European Union. It occurs when a national court pauses a case and asks the court to clarify how EU law should be interpreted. This ensures consistent application of law across all member states. For example, the National Court requested a preliminary ruling from the CJEU on the validity of the directive. The preliminary ruling does not decide the case, but it binds the national court regarding the legal question raised. This mechanism promotes legal harmony in the EU and reinforces the supranational authority of the CJEU. You'll hear key expressions such as refer a question for preliminary ruling, binding interpretation under Article 267 of the TFEU. The CJEU issued a preliminary ruling clarifying the scope of the regulation. In supranational law, enforcement is often indirect. Courts like the European Court and the Inter-American Court of Human Rights rely on member states and political bodies to implement their judgments. For example, the Convention provides an enforcement mechanism through the Committee of Ministers. That means a court can issue a judgment, but a separate mechanism must pressure or monitor the state to comply. In the European Court of Human Rights, the Committee of Ministers supervises enforcement. In the Inter-American system, it's the OAS General Assembly that follows up. This concept is important because the effectiveness of a binding ruling depends on how it is enforced. And you will hear key expressions such as strengthen enforcement mechanisms, political resistance can undermine enforcement, and follow-up procedures are part of the enforcement mechanism. Nearly all human rights courts require that an applicant first try every available legal avenue within their own country before filing internationally. This is known as exhausting domestic remedies. For example, applicants must exhaust domestic remedies before filing a case with the Inter-American Commission. This requirement protects state sovereignty and ensures that supranational courts are a last resort, not a first step. However, if domestic remedies are ineffective, excessively delayed, or simply unavailable, the requirement may be waived. You will hear key expressions such as demonstrate exhaustion of remedies, exceptions to the exhaustion requirement, and failure to exhaust remedies can result and inadmissibility. Unlike binding judgments, an advisory opinion offers legal guidance without deciding a specific dispute. These opinions are often requested by states or international organizations and aim to clarify legal questions of public importance. For example, the Inter-American Court issued an advisory opinion on the legal status of migrants. Although advisory opinions are not binding, they carry significant moral, political, and persuasive weight and are frequently cited in later cases. The International Court of Justice, ICJ, and the Inter-American Court both issue advisory opinions, often influencing national and international legal development. Key expressions you will hear are request an advisory opinion, or the court's advisory opinion was referenced in later jurisprudence, and advisory opinions shape international legal norms. In supranational law, it's important to communicate not just what a court did, but what it is legally permitted or required to do. That's where modal verbs are essential. Modal verbs help express legal authority. For example, the court may issue binding rulings under the convention, or procedural limits. The commission cannot refer the case unless domestic remedies have been exhausted. Obligations. Member states must implement the court's decision in good faith. Prohibitions. The court must not exceed its jurisdiction. Uncertainty or qualification. This provision might apply to cases involving cross-border enforcement. Modal verbs are powerful because they add precision to legal analysis. Let's break down a few examples. The Inter-American Court may consider advisory requests from OAS member states. Legal possibility based on treaty authority. States must not retaliate against petitioners who file claims, which expresses a legal prohibition grounded in human rights law. The CJEU cannot intervene unless the case involves a matter of EU law. This describes jurisdictional limitation, or the decision might influence future domestic rulings, but it is not binding. This shows qualified influence, not mandatory effect. In legal English, modal verbs help you distinguish what is required, what is allowed, and what is uncertain, all crucial when analyzing or explaining supranational court procedures. In legal writing and formal advocacy, we often need to express recommendations, conditions, or hypotheticals without directly asserting that something is true or guaranteed. That's where the subjunctive mood comes in, particularly in advanced legal English. The subjunctive is used after certain verbs and expressions such as recommend that, insist that, propose that, it is necessary that, important that, essential that. Notice that we do not conjugate the verb as usual. In the subjunctive, the verb stays in its base form. No S for third person singular. No past tense. Let's examine a few examples. It is essential that the state comply with a judgment, not complies. This structure emphasizes legal necessity in a neutral tone. Or, the court recommended that the law be amended. This allows the speaker to describe a proposed change without asserting judgment or obligation. 2. We propose that the application not be dismissed until further review. The use of not be instead of is not signals a formal procedural tone, especially common in petitions and court submissions. It is critical that counsel be present during all proceedings. This expresses a procedural requirement, not just advice. Why is this structure important in supranational law? Because courts often issue recommendations, procedural advisories, or jurisdictional conditions that are not yet rulings. And they need to be phrased carefully, professionally, and without assumption. This is especially useful when writing amicus briefs or petitions, interpreting non-binding legal instruments, quoting resolutions, declarations, or preliminary findings. The subjunctive helps maintain neutral tone, legal formality, and linguistic precision, all essential in international and supranational legal communication. This phrase is a core part of supranational legal procedure. To bring a case before the court means to initiate proceedings within the court's jurisdiction. For example, the organization brought a case before the Inter-American Court alleging systematic violations. This phrase is often used when the case arises after domestic remedies have been exhausted or when a state or commission submits it on behalf of a victim. Common contexts that you'll hear or see are human rights claims, treaty interpretation disputes, cross-border commercial or regulatory issues. Some common collocations are individuals may bring a case before the European Court of Human Rights after all domestic remedies have failed, or only state parties may bring a case before the ICJ under its contentious jurisdiction. This phrase is formal and widely used in international law. Declare a matter inadmissible. This phrase refers to an early stage procedural decision before the court examines the merits of the claim. If a party fails to follow procedural rules, the court may declare the matter inadmissible, meaning it will not move forward. For example, the court declared the application inadmissible due to failure to exhaust domestic remedies. Other admissibility issues include submitting the case too late, lack of victim status, duplicative filings in other jurisdictions. Common phrases you will hear are, the application was ruled inadmissible, or inadmissibility was based on jurisdictional incompatibility. Understanding how courts use this language helps lawyers explain legal outcomes diplomatically and precisely. Challenge jurisdiction. One of the most powerful tools a state or party can use in supranational litigation is to challenge the jurisdiction of the court. This is a procedural motion made early in the case, often focusing on the time the alleged events occurred, whether the party is a member or signatory, whether the subject matter falls under the treaty or statute. For example, the government challenged the court's jurisdiction on the basis of temporal limitations. This strategy is used to avoid examination of the merits entirely. Other contexts you'll see are counsel challenged jurisdiction, arguing the applicant lacks standing, or the tribunal rejected the jurisdictional challenge and proceeded to review the case. This phrase is common in oral and written advocacy before regional and international courts. Enforce a supranational judgment. Supranational courts don't have police or armies. They rely on states to enforce their decisions. To enforce a supranational judgment means taking real steps at the national level, passing laws, paying damages, reopening cases, or changing practices. For example, the state delayed enforcing the supranational judgment, citing constitutional constraints. This concept is central to the legitimacy of international law. Without enforcement, binding rulings remain theoretical. Other examples you'll see are the Committee of Ministers supervises enforcement of European Court of Human Rights judgments. Non-compliance with a supranational judgment may lead to political pressure or sanctions, or domestic courts must interpret laws in light of the enforced judgment. This phrase helps you explain the bridge between international obligation and domestic implementation. Imagine you're explaining the outcome of a complex case to your international legal team. A group of environmental defenders filed a petition before the Inter-American Commission, alleging state-sponsored harassment and failure to protect human rights. You begin, the petitioners exhausted all domestic remedies and had clear legal standing under the American Convention. Based on the facts, the Commission agreed to bring the case before the Inter-American Court. You explain the preliminary phase. The state challenged the court's jurisdiction, arguing that the events occurred before it had formally accepted the court's authority. However, the court found that its temporal jurisdiction was valid and proceeded. Then the next hurdle. Still, the court declared part of the claim inadmissible due to duplication in another proceeding, but allowed the core claim to move forward. So you describe the outcome. The court issued a binding decision requiring legislative reform and reparations. It is essential that the state comply with the ruling in full. And now comes the difficult part: enforcement. The court's decisions are binding, but enforcement depends on the mechanism within the OAS system. If the state delays, the Commission may refer the matter to the General Assembly. And your colleague asks, could the court issue further guidance? And you reply, the court may issue an advisory opinion, but it cannot reopen the case unless new admissible facts emerge. You finish with this assessment. This case highlights the complexity of supranational enforcement. The court must not overstep its jurisdiction, but the state must fulfill its obligations in good faith. This is the language of real-world supranational litigation. Now you have the tools to navigate it confidently in English. Let's wrap up. Today you explored the complex but essential language of supranational courts. These institutions, like the European Court of Human Rights, the Inter-American Court of Human Rights, and the Court of Justice of the EU, require a very specific legal vocabulary. You now know how to talk about jurisdiction and admissibility, explain who has legal standing and what it means to exhaust domestic remedies, describe how binding decisions are issued and what it takes to enforce them. You can use modal verbs to define legal obligations and limits, and apply the subjunctive to frame formal recommendations or conditions, and also use legal phrases that international lawyers and judges recognize around the world. This is advanced legal English, and it's the kind of language that builds credibility in cross-border legal practice.